Good afternoon. It is the 11th of October 2018. My name is Robert, and I'm doing a video for Forest of Trees. Now that Judge Kavanaugh has transitioned into Justice Kavanaugh and been confirmed to the Supreme Court, I thought that I would talk about the presumed danger that he is to Fourth Amendment protections. And I noticed leading up to his confirmation battle that there were a lot of voices on the right, such as Judge Napolitano of Fox News, that would routinely talk about how he is, and I quote, no friend of the Fourth Amendment. However, looking back at the various accusations against Kavanaugh, I was reminded that it's important to find corroborating evidence of any accusations. And so I started doing a lot of reading, and the more that I read, the more that I realized that I'm not really all that concerned about Kavanaugh on the Supreme Court any longer. And the reason for that is that it appears that he is very focused and very respectful of Supreme Court precedent. And I can go into some detail here. So I'm going to lead up with some background on some cases that sort of paved the way to where we are today. And one of those is from 1967, where a lawsuit of Katz versus United States made its way up to the Supreme Court. And the gist of the case was that there was some evidence obtained by the law enforcement agencies that the defense thought should not have been admissible in court. And it turns out that Katz, who was under investigation, had a favorite telephone booth that he liked to make some calls from. And it was observed that this was his favorite booth, and so law enforcement decided that, hey, telephone booth is in public. You know, we don't have to get a warrant because if you're in public, there's no expectation of privacy. It turns out that the law enforcement was incorrect in their assessment because as the Supreme Court decided, if you are in a telephone booth, you've got the door, you close the door behind you, and then you put your money in to pay your toll, and because you're in an enclosed space, and you're talking into a little mouthpiece on the handset rather than through a megaphone, that you have a reasonable expectation of privacy. And because of that expectation, that if law enforcement wants to spy on you, they need to have a judge okay it. And that sort of set the groundwork for, the, we'll say, modern technology and the way that it can affect how you are observed and surveilled by police. Now, just a decade later, in 1979, there was another case, and that one was Smith versus the United States. And now, in this particular one, Smith had a problem with the fact that the United States law enforcement agencies could go to a third party, such as Sprint or AT&T, and get records of all of the telephone calls that were made. And because of those records, they would know who the call was made to, how long the telephone call lasted, and you can build a lot of information based off of just that. And the United States Supreme Court decided that because the telecommunication companies were third parties, similar to, say, witnesses on the street to an alleged crime that occurred, and that the records that they maintained were not records that Smith was maintaining himself. And in addition to that, there was no reasonable expectation of privacy because it was understood by Smith and all other users of the telephone systems at the time that the telephone companies would maintain records of your calls. Because after all, if you're making long distance calls and they're not maintaining records of it, how are they going to charge you for your time? And that really expanded on the previous case, where you say, okay, there are definitely protections, and there are exceptions to those protections, and a lot of it is just based off of expectations of privacy. If you kind of expand those thoughts to modern day, you've got your iPhone or your Samsung phone, and as we've been discovering over the past couple of years, unfortunately it's not been widespread news, but it's been out there. There are a lot of companies like Google with their Chrome browser and their map applications where, if you're using Google's Maps to navigate you around town, Google is taking note of all the places that you've been and all the places that you searched for on those maps. And if you are going around on the World Wide Web with Chrome, you're getting cookies on your browser. And it's not just Google that can take a look at those cookies and see where you've been. Any website that you go and look at can take a look at those cookies and say, oh, they go to Amazon a lot and they search for, trampolines. So let's start trying to find advertisements for trampolines that we can plaster all over their screen and maybe get them to make a purchase. And, Facebook is particularly creepy. I just recently rejoined Facebook because it's just convenient to be on Facebook when everyone else is on Facebook. But the reason that I quit 6 months ago was because, as a result of my job, where I go around to, anywhere from 50 to 100 locations a day, making deliveries, that the Facebook app was noting everywhere that I was and when I was there, and it was making associations with everyone in that building that I was visiting who had the Facebook app, and saying, oh, it's possible that Robert knows this person since he's there 4 times a week. Maybe we should start recommending that they become friends on Facebook. And I thought that was getting to be kind of creepy, and so I left Facebook for a time. But, I'm just using those as examples of the fact that there are a lot of third parties that are keeping track of what we're doing. And so it's definitely important to be aware of the fact that that the government and the Supreme Court may not necessarily agree with you that you have an expectation of privacy. And we should probably be doing a lot better job of reading the terms of service, everything that we use, especially the parts where they talk about selling or volunteering your data to other third parties. Now, in 2012, there was another case, Jones versus the United States. And the issue was that there was this fellow, Jones, who was being investigated by the police and the FBI. And law enforcement went to a judge and they said, hey, we want to stick a GPS tracker on this dude's car because we want to figure out where he's going and where he may have been in the past based on his future destinations. And the judge said, sure, but you got to do it inside the District of Columbia, and you have 10 days to stick this GPS device on his car. Unfortunately, for the law enforcement agencies involved, they did not put the GPS device under his vehicle until the 11th day, and when they put it on his vehicle, he was in Maryland and not in the District of Columbia. So pretty much every aspect of the warrant that the judge laid out for, the specifics of what they're allowed to do, they failed on. They failed on every way that they could have failed on. But for a lengthy period of time, they had a GPS tracker on this guy's vehicle, and they were able to know all the places that he was going. And his case rather made it up to the Supreme Court, and the Supreme Court was not happy with the law enforcement, and they said, no, you can't do that. And one of the reasons that they were concerned was that it was definitely a search of his vehicle, because they had to actively put the GPS device on his vehicle. It wasn't like they were tailing him from a block and a half back and just watching him through telescopes. They actually had to actively do something to Mr. Jones's possessions. And that leads us to the Carpenter case, where Chief Justice Roberts actually joined with some Democrats in saying that, hey, no, there are some privacy considerations that need to be maintained. And the issue in Carpenter was that there was this guy that the police, because of a capture of a robbery gang member, they believed him to be a mastermind and a leader of this group of criminals that were going around and robbing electronics stores. But they needed more than just, what this guy that they captured said. So they went and they started monitoring the location of Carpenter over a lengthy period of time, just using cell phone data and where his phone was reporting its position to whatever tower it happened to be talking to at the time. And cell phones can do this several times a minute. So you have a very granular idea of everywhere that this person is. And, I'm reminded of, history back in the days of our founding fathers and the War of Independence with Britain, where historians and intelligence analysts have talked about how if the British had a modern day knowledge of intelligence and associations, that they could have simply shut down the revolution before it began merely by monitoring everyone that would frequent certain bars and all the other people that would frequent those bars. And you would start being able to map associations and say, Jimmy keeps going to this particular pub every Thursday, and that these other 4 people keep going to the same pub every Thursday that Jimmy's there. And you've probably seen, in the movies where the police are trying to figure out who's associated with who, and they've got pictures on a wall, then they start, taking their red string on tacks and taking that string from, one photo on the map, and then they string it over to somewhere else, or they might have a whole bunch of strings going to a particular location, just so that they can see everyone that's associated with that location. And then you say, oh, well, these 5 people keep being associated with this one location, and we know that 4 of them have a criminal record, so let's start seeing everyone else that's associated with these people, and then we can look for more associations between those people and everyone else that we have on our map, and pretty soon you've got red strings everywhere, but you also have a really good picture of who might be working with someone else. And the reason that's important, where I'm talking about that, is because when you're looking at the level of granular data that geolocation on a cell phone can give you, since it's reporting its location, several times a minute, you have an idea of not just where somebody has been, but you have an idea of when they were there and who they were with. Especially if the police do a tower dump on a particular time, they can say, frequently without a warrant, they can say, hey, Verizon, we need to know every phone that was talking to this particular tower at this particular time. And they can get that particular time because if, say, they're following, Jim Skippy, who they think was involved in some sort of crime, and they know that he was at, say, Safeway doing his shopping at 4:57 p.m., and the closest Verizon and AT&T towers to Safeway are these 2 particular towers, and they can just say, hey, let us know every cell phone that was talking to these 2 towers. And, they don't care that the majority of all the other people at Safeway were also talking to those towers while their phones are just sitting, doing nothing in their pockets. They look at the names of those people, and if they're not known criminals and they don't seem to have an association, they throw them away, or at least they should throw them away. They're just looking to say, someone else that is a known bank robber, happened to be going to Safeway at the same time. And then 3 days later, the known bank robber and this particular dude we're following also happened to be at an Albertsons at the exact same time. And they were both there for about 20 minutes. So, hey, we might want to follow this bank robber because it's possible he's associated. And, even beyond that, it gives patterns to your life. It's like you go to church every Wednesday and every Sunday. You go shopping every Thursday and every Saturday. You go to a bar at this particular time every day. You seem to have these groups of friends that you keep talking to, at that bar. It's more than just following you and seeing where you are. Because of the granular data and the way that the police can follow up without a warrant, it really provides an in-depth look into your life. And because of that, Justice Roberts, he was really concerned about the implications of that. And, in his view, and correctly I think, generally when the government wants to take a detailed snapshot of your life, that snapshot is an intrusion of your privacy. And because of that intrusion, it's expected that some judge or magistrate is going to need to sign off on a warrant for it. And, just because the information that is being gathered is from a telephone company that is a third party, the level of information now isn't limited like it was back in the 79 when it was just, who are you talking to? There's so much that can be derived from simple bits of information on your location now, and that it's too intrusive. And Robert said so, and they kicked those law enforcement down a peg because of it. And the reason all of this is important is because Kavanaugh, who was part of the Bush White House, which I'm not going to blame him for. Bush had his faults, and I'm not going to blame Kavanaugh for taking an opportunity to have a high-profile job in the Bush White House. But in a particular ruling, back when Edward Snowden, told the world about the existence of the NSA bulk metadata collection. And if you're not familiar with it, the metadata is all the information about your call that is not the call itself. So they're not recording the audio of the telephone call, but everything about it, from when you made that call to who you called to how long that call was, and to even the location of all the parties in that call. That was being recorded so that our intelligence agencies could look for patterns. And it's a very useful technology. It's really easy to see how it'd be useful in the war on terror. However, the way that the government is doing it is that they're just scooping up all the data. And basically it's enabling them, because they're looking for patterns on all the data, not just data against people that they're investigating, it's able to flag people for investigation, which, from a privacy standpoint is a very big deal, right? And somebody sued the government, say, hey, I want to be excluded from this. And if you don't want to exclude me, then prove that I'm a terrorist, or go and kick some sand, right? And it got up to the District Court of Appeals in D.C., and Kavanaugh was ruling on it, and he looked at precedent. When he specifically looked at the Smith versus the United States case from 1979, and he said, hey, all Supreme Court precedent basically says that when you're just looking at the metadata of the communication, that there's third-party doctrine in effect, which basically means that third parties are witnesses and they can testify against you if they feel like it, and that you don't have a reasonable expectation of privacy. And Kavanaugh was right. He was, well, let's not say right, let's say Kavanaugh was correct. Because that 1979 case was was heavily established precedent that was used in numerous amounts of cases in the intervening years between then and now. And for him to go against that precedent would make him basically an activist judge. But then, and I think this is important, when he was being questioned by Senator Leahy for his confirmation to the Supreme Court, the senator asked him, said, hey, looking back on Justice Roberts' opinion in Carpenter, where he said that it is unacceptable for the government to go and scoop up massive amounts of location data on a particular person without a warrant, how would that lead you to have an opinion on the NSA metadata case? And Kavanaugh, what he said was basically if Justice Roberts had his opinion for Carpenter before the Court of Appeals case that Kavanaugh was on was decided, that there is no way that Kavanaugh would have been able to come to the opinion that he did. And I think it's good that he's able to go and admit that. And it shows that he has a respect, again, for the president of SCOTUS. And as he even said during that confirmation, he said that Justice Roberts' opinion was a game changer. And he's completely right about that, because it basically overturned Smith's, well, it didn't overturn Smith, but it made it so that Smith is no longer in effect, because all previous cases are no longer suddenly free to go back up and be reheard again. So it wasn't overturned in that matter. But now, whereas every other case, the judge would just point at Smith and say, no reasonable expectation of privacy, suddenly now there is a reasonable expectation of privacy. And a lot of that is just because the technology is just so pervasive now. But, with that in mind, obviously we are going to find out in the coming years about exactly what kind of a person Kavanaugh is when he's setting precedent, instead of, having to align himself with precedent. I think it's promising that he is on a court with, other conservative justices. And even to her credit, Sotomayor appears to be fairly, we'll say, friendly towards Fourth Amendment concerns herself. She has personally, in her dissents on cases, blasted the idea of third-party doctrine, and the idea that, we'll say, companies that are not, actually people and witnesses on the street could be a witness against you. So I think that things aren't as bad as they initially seemed, and obviously we're going to have to pay attention to what Kavanaugh does in the future, but I think we got some bright days ahead of us. And I would love to hear in the comments what everybody thinks about this. We have opinions on what we can see, and there's a lot that hasn't happened yet. He'll probably be on the court for 40 years. So he's got lots of opportunity to either strengthen or damage our protections. Hopefully it's the former. And if you liked this video, or if you just found it interesting, please hit the like button. It really helps. And if you'd like to hear more, hit that subscribe button. It also helps. Both the like and subscribe are what the YouTube algorithms in the background use to determine whether videos are going to be presented to others as something that they might like to watch. And I hope everybody has a good day, and maybe I'll see you at tonight's CFL meeting.